Canadapost, a Crown corporation trusted to uphold fairness and equality, repeatedly violated federal law, workplace policy, and Supreme Court principles. 20 legal and policy breaches, denied fairness. One by one, here are just 20 legal and policy breaches Canadapost committed. One by one, here are the 20 legal and policy breaches Canadapost committed. 1 conflict of interest, policy ignored. A confirmed violation was ignored with no discipline issued. This selective enforcement breaches Canadapost's own conflict of interest policy, Ontario, Ministry of Community and Social Services, and Ontario Public Service Employees Union, Ontario Grievance Settlement Board, found that ignoring proven violations constitutes discriminatory enforcement. 2 unequal discipline and termination. 1 employee was terminated, while others with the same or greater misconduct faced none. Toronto Transit Commission and Amalgamated Transit Union, Local 113, Ontario Labour Arbitration, ruled that unequal discipline amounts to wrongful termination. 3. Failure to combine related investigations. Complaints involving the same people, same events, and same timelines were handled separately. This violates Bill C-65 under the Canada Labour Code, which mandates fair and transparent resolution processes. Merrifield v. Canada, Attorney General, Ontario Court of Appeal, held that consistent treatment is a cornerstone of natural justice. 4 witness evidence ignored. Key witnesses were never interviewed. This violates the fundamental duty of procedural fairness. Baker v. Canada, Minister of Citizenship and Immigration, Supreme Court of Canada, confirms that ignoring relevant witnesses breaches fairness. University of British Columbia v. Kelly, British Columbia Court of Appeal, ruled that excluding witnesses invalidates investigative integrity. 5 selective evidence gathering. Only one side's evidence was considered. Administrative fairness requires equal weight for both parties' evidence under Baker v. Canada. 6 complaints labeled bad faith, without proof. Legitimate complaints were dismissed as retaliatory with no objective evidence. Canadian National Railway Company versus Canadian Auto Workers, TCA Canada, Ontario Labour Arbitration, held that allegations of bad faith require proof. Skinner v. Professional Institute of the Public Service of Canada, CUO, Federal Public Sector Labour Relations and Employment Board, reaffirmed that counter-complaints are not automatically frivolous. Canadapost denied there was harassment and called my complaints frivolous, but later confirmed by another federal board's independent investigation. The harassment Canadapost tried to hide has been exposed. 7 retaliation. Not investigated reprisal claims were ignored despite being a protected right. Walsh v. Mobil Oil Canada, Alberta Court of Appeal, held that retaliation must be investigated whenever a link to a prior complaint exists. 8. Failure to act on legal no-contact breach. Contact occurred during an active no-contact order. Ignoring this breached the Canada Labour Code, Section 122.1, the duty to ensure workplace safety and prevent retaliation. 9. Dismissal of harassment and defamation. Multiple reports of workplace defamation and abuse were dismissed without review. Nicholson v. Haldimand Norfolk Regional Police Commissioners, Supreme Court of Canada, established that failure to investigate before discipline violates fairness. Off-duty harassment dismissed. Vandalism, social media, and Discord-related harassment were labeled non-workplace. Capobianco v. Toronto Catholic District School Board, Human Rights Tribunal of Ontario, ruled that off-duty conduct impacting the workplace can constitute harassment. 11. Prejudicial language in reports. Investigative reports used biased terms like insincere and abusive process. McDonald v. Canada, Attorney General, Federal Court of Canada, held that prejudicial tone or language can prove institutional bias. 12. Misuse of intent to dismiss harassment. Investigators claimed conduct wasn't harassment because intent wasn't proven. Kavanagh v. Kavanagh, Alberta Court of Queen's Bench, confirmed that harassment is judged by impact, not intent. 13. Unequal evidentiary standards. One side's claims were trusted, the other dismissed. Toronto District School Board v. Ontario Secondary School Teachers Federation, Ontario Labour Arbitration, found that inconsistent credibility assessments amount to bias. 14. My complaints, denied, delayed, harassment left unchecked and allowed to continue. Counter-complaints filed to stop workplace harassment were never investigated properly. Murray v. Canada, Correctional Service, Public Service Labour Relations and Employment Board, held that failing to examine retaliatory complaints breaches natural justice. 15. Psychological safety ignored. Verbal abuse and hostility were unaddressed. Violates Section 122.1 of the Canada Labour Code, the duty to protect employees' psychological health and safety. 16. Discriminatory enforcement of policy. Policies were applied selectively based on gender and relationship status. This breaches the Canadian Human Rights Act and administrative fairness principles. 17. Denial of report access and preparation time. No access to the investigation report and less than 24 hours notice for response. Violates Association of Postal Officials of Canada Collective Agreement, Article 14.1. Right to representation and adequate time to prepare. 18. Prejudgment by management and management acknowledgement that my outcome was predetermined. Management cited findings of guilt before the hearing concluded. Kane v. University of British Columbia, Supreme Court of Canada, held that decision-makers must remain neutral until all evidence is heard. 19. Denial of representation rights. Meetings were held without proper notice or disclosure of evidence. Violates both the APOC collective agreement and Baker v. Canada principles of procedural fairness. 20. Suppression of exculpatory evidence. Evidence that cleared the accused was withheld or ignored. Baker v. Canada, Minister of Citizenship and Immigration, Supreme Court of Canada, affirmed that all relevant evidence must be considered before deciding. These actions breached Bill C-65, the Canada Labour Code, the Workplace Harassment and Violence Prevention Regulations, the Conflict of Interest Policy, and the APOC Collective Agreement. These aren't opinions, they're legal precedents Canadapost ignored. And these are just a few, there are many more. 20 breaches, zero accountability, due process is not optional, it's the law. Canadapost denied fairness. Share if you believe in due process. Share if you believe in equality, fairness, and standing up for your rights.